Secondly, we all know that maximization of value of the corporate debtors assets. Thirdly, being the timely resolution of insolvency proceedings. So the code basically is largely a document of civil repercussions, but recognizes certain offenses that entail prosecution and penal actions. So overview of the penal provisions. So offenses and its punishment are enshrined under Part 2 of the code, and which starts with 68. Obviously, there are here and there a few other sections as well. So let us start with one of those sections first. Section 68, concealment of property. And this is where sir's question might have been or could be answered, that it prescribes an imprisonment to an officer of the corporate debtor for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine, which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. And so the essential ingredient over here would be that intent to conceal any property of the corporate debtor. And the look back period given here is 12 months from the insolvency commencement date, and any time thereafter as well. So even after the CIRP is initiated, and then at that time, some of or one of the personnel of the corporate debtor is concealing the property, then also that person is covered under this section. Section 69, transactions defrauding creditors. So this prescribes an imprisonment to an officer of the corporate debtor for a term which shall not be less than 1 year, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. So over here also the essential ingredient is intent to defraud, and look back period given over here is 5 years preceding the insolvency commencement date. Section 70, misconduct during the CIRP, which also prescribes an imprisonment to an officer of the corporate debtor for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. In this section, there is also a provision for punishment to insolvency professionals as well, which reads something like that. Obviously, we have paraphrased it here, that if an insolvency professional deliberately contravenes the provisions of the code, the word deliberately needs to be highlighted here, then is punishable with an imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees, but may extend to 5 lakh rupees, or with both. So misconduct during the CIRP, it can be filed by any person against the corporate debtor, their officers, or by any person against the insolvency professional. And please kindly keep on writing the questions, and we'll answer at the Q&A session at the end, because if I start answering now, there will be a gap in the flow, which I believe would be a roadblock for a lot of us to understand. Continuing, section 71, falsification of books of corporate debtor. And this is only applicable from the insolvency commencement date, unlike the POFE. So prescribes imprisonment to any person for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. The highlighting portion over here is twofold. Number one, applicable from the commencement date, ICD. Second highlighting point is to any person. So there is no bar on against whom it can be initiated. Section 72, willful or material omissions from the statements about affairs of the corporate debtor. Prescribes an imprisonment to an officer of the corporate debtor for a term which shall not be less than 3 years, but which may extend to 5 years, or fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees or with both. The interesting part over here is for willful / material omission from the statements about the affairs of the corporate debtor, there is no look back period. It is more like section 66. There is no look back period. But again, someone complaining this would have to prove the willful or material omission from the statements. Section 73, false representation to creditors, which prescribes imprisonment to any officer of the corporate debtor. Now, over here, it's any officer of the corporate debtor. It's not any person. And please kindly make a distinction between these two phrases. So, any officer of the corporate debtor for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. And over here also, there is no look back period. Next section is section 74, contravention of moratorium or resolution plan, CD or its officer. And this has been widely used by us as counsels and you as insolvency professionals. Contravention of moratorium or resolution plan. Corporate debtor or its officer, imprisonment for a term which shall not be less than 3 years but may extend to 5 years. Creditor and or anyone on whom resolution plan is binding, imprisonment for a term which shall not be less than 1 year but may extend to 5 years. In all cases, fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees, or imprisonment, or both. So it gives to the CD or its officer, creditor, or anyone on whom the resolution plan is binding. Section 75, false information furnished in Section 7 application, which prescribes fine for any person which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. This is very particular for Section 7, that if any person who's filing as a financial creditor a Section 7 application before the adjudicating authority, if he, she, it, anyone gives a false information, then this penal provision can be invoked. Section 76. This is qua the operational creditor. Non-disclosure of dispute or payment of debt by operational creditor, which prescribes an imprisonment to an operational creditor or any person authorized, because we all must have filled up that form while filing Section 9, person authorized, right? For that person is also covered here. For a term which shall not be less than 1 year, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. Section 77. False information in application made by the corporate debtor in Section 10, which prescribes an imprisonment to the corporate debtor or any person authorized for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore, or with both. So we have seen Section 7 applicant, operational creditor in 8 and 9, obviously, and Section 10, the corporate debtor or the corporate applicant itself. Section 77A, offenses related to pre-packaged insolvency resolution process, which prescribes to the corporate debtor or the person authorized for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees, but may extend to 1 crore rupees, or with both. Over here, it is only to the corporate debtor or the person authorized on behalf of the corporate debtor. So there are further offenses and its punishment which are enshrined under Part 3, that is for personal insolvency, Section 184, which is for punishment for false information. That if a debtor or creditor So here we are covered under 94, 95, everything, because it uses the word or. So if a debtor or creditor provides information which is false in any material particulars to the resolution professional, he shall be punishable with imprisonment for a term which may extend to 1 year, or fine which may extend to 5 lakh rupees, or with both. And if a creditor promises to vote in favor of the repayment plan dishonestly, he shall be punishable with imprisonment for a term which may extend to 2 years, or with fine, or with both. So both the teething powers have been given here: false information, as well as any person or any creditor promising to vote in favor of the repayment plan dishonestly. 185. Punishment for contravention provisions. If an insolvency professional deliberately contravenes the provisions of this part, and here the duty is casted upon the IPs as well, and therefore, if there is a deliberate contravention from the side of the insolvency professional, then he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees, but may extend to 5 lakh rupees, or with both. Then there are two more sections, 186 and 187, which is similar, which we have seen earlier for the IPs as well as the debtors and creditors, which is here for the personal insolvency matters, which is for the purposes of false information, concealment by the bankrupt, and punishment for misconduct of the bankruptcy trustee. It is para materia. There is a section 235A as well, which prescribes or gives out the punishment where no specific penalty or punishment is provided for in the code. So it reads something like that prescribes fine qua any person who contravenes any of the provisions of the code, which shall not be less than 1 lakh rupee, but may extend to 2 crore rupees. Here the upper limit is of 2 crore rupees. And highlighting portion is any person. 236(1) of the code bestows jurisdiction to special courts. And before coming to this slide, I want to now shift the focus from the penal provisions to the provisions which entail us for a very prescriptive or descriptive procedures, how it is to be followed. And this is where all of us in the initial phase have fumbled. So it's now time that we all be familiarized with these kind of sections so that we know what's the proper channel, what's the proper procedure to be followed. So 236(1) of the code bestows jurisdiction on special courts as established under the Companies Act to try the offences under the code. Further, as per 236 subclause 3, the special courts will be the courts of session, and the persons conducting the prosecution will be a public prosecutor as far as the code is concerned. And this is very explicitly mentioned in the code. Code also prescribes the appellate structure under the penal provisions of the code. So what happens if some matter goes to a special court? If someone is aggrieved, of either of the parties aggrieved, wants to go and utilize their right or exercise their right of appellate jurisdiction, how that person would be doing it. So 237 designates the High Court within the local limits of the jurisdictional special court as competent forum for appeals and revisions. Now, what are the jurisdictions of the special court? The special courts under 236 cannot take suo motu cognizance of any offense under the code. And we have to remember this very crisply, that special court cannot take a direct cognizance. Cognizance of offense under the code can only be taken by special courts, and for which 236 subclause 2 gives three conditions, or three players rather. First, very important player is IBBI, that a complaint is made by IBBI with the special court. Second, a complaint is made by the central government. that is ROC, RD, SFIO, all the governmental agencies. Thirdly, the complaint is made by any person authorized by the central government. So it has to be very clear that cognizance part, suo motu powers have not been given. There's a proper mechanism or channel given for which IBBI and the central government are the two main pillars. Now let us look at some case laws so we would understand that have there ever been these penal provisions invoked? And this was in the introductory remarks we were just pondering upon that have that been done? Yes, there are few cases and I would want to highlight few of them. This is a special court Dwarka of 2020 where IBBI has filed such a case. So the application was filed by IBBI against the KMP of the corporate debtor for non-cooperation with the RP. And as per the provisions contained in 236(2) of the IBC code, the complainant, so highlight word now is the complainant who has filed its IBBI, has power to set the criminal law into motion through its authorized officer. And what has happened in this case, after considering the documentary evidence placed on record, the special court was satisfied of the offences prima facie committed and hence cognizance was taken. So now we know the understanding, or now we know the flow that IBBI, let's say an IRP or RP has made a complaint to IBBI of non-cooperation. That has been taken forward by IBBI to the special court. Special court has seen the powers that IBBI can bring. And then, because there was a prima facie case, the cognizance was taken by the special court. So that is the channel which is to be followed. There's one more case of 2019 of the same Dwarka court. Again, same circumstances or similar circumstances that IBBI against the KMP of the corporate debtor for the non-cooperation. But over here, the CD was undergoing the liquidation and KMP has refused to provide the details of the assets which would be for sale. And as per the provisions of the code, the complainant has powers to set the criminal law into motion through its authorized officer. And after considering the documentary evidence, in this case also the special court was convinced and satisfied that there's a prima facie evidence of the case and hence the cognizance was taken. Again, a Dwarka special court matter of 2019. Application was filed by IBBI again against the KMP of the corporate debtor for non-cooperation with RP. The RP was unable to gain the access to the books of accounts of the corporate debtor due to no response. And as per the provisions of the code, that was also taken cognizance by the special court. Now, there's one more case of 2019 of Gurugram, where the application was filed by IBBI against the KMP of the corporate debtor for not disclosing the details of the properties and transactions of the corporate debtor to the resolution professional. And hence, in this case also, while exercising the power under 236, IBBI has approached the special court. Special court, after going through the documentary evidence, prima facie was of an opinion that a cognizance is to be taken and the case was taken into consideration by the special court. Umesh Kumar Sharma, was filed through IBBI only. Mrs. Bhuvana Infra Projects, Special Court, Bangalore. Here the application was filed by IBBI against the KMP of the corporate debtor for non-cooperation with the RP. And the accused also made false representation for the purpose of committing fraud and refused to disclose the books and documents to the corporate debtor. And here also, as per the exercise enshrined under 236(2) of the code, the IBBI had the power who approached the special court. Special court took the cognizance and the matter was taken up. Now, there are two cases of Liberty House Group, and I'll show you both. And it's a very interesting thing that how these two are different in nature, but very similar in terms of the offense. The application in this matter was filed by IBBI against the KMP being the CFO and CEO, because here we are talking about, and I'm sure all of us are now that mature, that for someone to be put behind the bars, we would need some personnel, right? So here it was CEO and CFO of the successful resolution applicant of the corporator for the contraventions of the terms of the resolution plan. And prima facie, the case was made against the accused, and hence the cognizance was taken. This is qua the successful resolution applicant who did not fulfill the commitment as given in the resolution plan as approved by the adjudicating authority, and the terms enshrined under that resolution plan were not adhered to by the SRA. Therefore, the CFO and CEO were punished. Now, same case in a Cuttack bench of special court, IBBI filed against the successful resolution applicant of the corporate data, that is to the entity, for contravention of the terms of the resolution plan. And again, this was also taken into cognizance by the special court. So one, qua the SRA as entity, another qua the SRA represented by the KMPs, that is CEO and CFO, and both were taken cognizance of at two different or distinct levels. Now, therefore, there are two essential ingredients as exposited herein above for the special courts under the code to take cognizance of penal contravention under the IBC framework. What are those two things? That a complaint is made by IBBI or central government, as the case may be, and there being a prima facie case of violation of the provisions of the code attracting penal provisions. If when these two facts meet, then only this penal provisions can be invoked. Now, moving on to the next phase or next limb of our session, powers of IBBI to investigate. And here we will be talking about the powers of Insolvency and Bankruptcy Board of India, that in addition to making a complaint to special courts, which IBBI has obviously powers, and then only the special court will be able to take the cognizance of, IBBI also has inherent powers to investigate an insolvency professional or insolvency professional agency. Let us look at few of the sections which are mentioned under the code. 196, powers of IBBI to investigate and pass orders against insolvency professional agencies and IU, all three. 217, and it reads as follows: any person aggrieved by functioning of an IPA or IP or an IU may file a complaint to the board in such form, within such time, and in such manner as may be specified. And 218, IBBI has the power to launch an investigation against an insolvency professional or insolvency agency upon receipt of complaint. So they can do it suo moto as per their inherent powers, as well as by taking a cognizance of a complaint made by any person to IBBI. So IBBI Inspection and Investigation Regulations 2017, and two regulations are important for us. One is 11 and another one is 13. So 11 reads that if the IBBI is of the prima facie opinion that sufficient cause exists to take action again under section 220 or subsection 2 of section 236. So either ways, in both the scenarios, it shall issue a show cause notice in accordance with regulation 12 to the service provider or an associated person, and in any other case, close the inspection or investigation as the case may be. So therefore, the IBBI can also initiate an investigation against an IP under section 218 of the code and make a complaint before the special courts on its own initiative under regulation 11 read with regulation 13(3)(d). Yes, moving forward. Part 2, that is section 7, punishment for misconduct during the CIRP, and part 3, section 185. What it says is, if an insolvency professional deliberately contravenes the provisions of this part, he shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees but may extend to 5 lakh rupees, or with both. So 70 is for the CIRP, 185 is for the personal insolvency. They both are paramateria to each other. So as per the provisions of the code and the rules and regulations so framed thereunder, neither the Honorable NCLT nor the IPs can take cognizance of and initiate prosecution. So IPs can't, even NCLT cannot. Neither the NCLT nor the IP can direct special court to take cognizance. It is only the IBBI or the central government. Neither the NCLT nor the IP can make a complaint suo motu to the special courts. So the channel is that NCLT or IP to IBBI, IBBI to special court. There is no shortcut here. But having said that, Honorable NCLT, being an adjudicating authority, can refer or felicitate the matter before the IBBI or the central government, as the case may be. And we must have seen this in many orders of many adjudicating authorities or NCLTs pan India, that they have in the last line of the order mentioned that the copy of the order may be placed before IBBI or to be communicated to the IBBI. And the reason is this. That is the power they have. And before I move forward, let us take a moment, pause here and think. This is distinct, which is a penal provision or penal action, vis-a-vis the contempt jurisdiction of NCLT. So under contempt, where a order has been passed by the tribunal, for that order, the contempt jurisdiction is exercised by the same NCLT. But here we are talking about the penal provisions for the contraventions under the code, which is distinct and separate. I hope I was able to make it clear. Now let us look at the final leg of my PPT, and then we can open the floor for open discussions and questions and answers. The case laws. And this is where even, I will be very honest that even I have fumbled here in the initial stage when the code was introduced. And obviously, we all have learned through the process. So Sappan Mohan Garg, the RP of Sort India Enviro Solutions versus Manish G. Patel and another. This is an NCLAT judgment. And I've extracted few paras here, which we may read, that it has been held that the RP is not empowered to initiate the prosecution, but at the same time, it has held that in order to initiate prosecution under section 70, that is contravention, the complaint has to be filed by IBBI or central government or person authorized by the central government. In view of the aforesaid facts and circumstances, we do not find any error in the order of the learned tribunal. Therefore, the present appeal is hereby dismissed. So the appeal was filed by the RP, that was dismissed because he invoked section 70, NCLT rejected. He came before the NCLAT. NCLAT also said, no, I'm rejecting the appeal. However, and this is where the whole wisdom lies, liberty is granted to the RP to file an appropriate application to IBBI in this regard, if so advised. So again, we'll come back to the same channel, that from IP to IBBI, IBBI to special court. NCLT does not have jurisdiction. You as IP do not have jurisdiction. Hence, you could not have invoked. That is what was held by the Honorable NCLAT. One case of 2025 of Bombay bench or the Mumbai bench. In view of the foregoing, we set aside the transactions impugned in the present application and direct respondent number so-and-so to refund so-and-so amount, respectively, within 30 days. Further, the respondent number so-and-so shall be jointly or severally pay the amounts to the corporator in addition to respondent number so-and-so within 30 days, skipping those two lines. The liquidator is directed to inform IBBI to initiate proceedings in terms of section 74(1) of the code, violation of moratorium or the resolution plan. So the amount For refund of amount, for getting the amount back into the corporate debtors account or the corporate debtors account under liquidation, proper application can be made. Penal provisions under the code cannot be initiated by the IP, IRP, RP or liquidator before the NCLT. But NCLT Mumbai bench in this case directed the RP or the liquidator in this case to initiate proceedings in terms of 71 of the code. Accordingly, the MA was disposed, and this matter was upheld by the Honorable NCLAT as well when it was challenged before the Honorable NCLAT. Regional Provident Fund Commissioner versus Excel Glass. This is NCLT Kochi Bench Order of 2023. Para 14 reads as that the applicant knowingly flouted the moratorium order and proceeded with the proceedings under Section 7Q and 14B of the Employees Provident Funds and Miscellaneous Provisions Act 1952. Thus, committed an offence punishable under Section 74(2) of IBC. This section is criminal in nature, falls under Chapter 7 under the heading Offences and Penalties. Under Section 236(1) of IBC, special court alone have jurisdiction. Further, under 236(2) of IBC, cognizance of the offence can be taken only on the complaint of IBBI or central government. Hence, the second respondent, in this case, the second respondent was the liquidator, is granted liberty to approach IBBI to proceed against the applicant's erred officials in this regard. Then there's one more NCLAT judgment of 2022. In the event the requisites, cooperation and information not supplied and any offense is committed within the meaning of Section 70 of the code, it is true that neither the adjudicating authority nor the resolution professional can initiate prosecution under Section 70, and prosecution under Section 70 can be initiated only in the manner provided under Section 236. Thus, the prosecution under Section 70 has to have been a complaint filed by the board or central government or person authorized by central government. The submission of the learned counsel for the appellant that the resolution professional is not empowered to initiate the prosecution is correct. We thus clarify that any prosecution under Section 70 can be initiated only in accordance with the procedure as provided under Section 236 subclause 2 and not by the resolution professional. One more judgment of Honorable NCLAT. In view of the aforesaid position of law, we hold that the tribunal or adjudicating authority, on receipt of application complaint of alleged violation of the aforesaid provisions, and on such consideration and being satisfied that there are circumstances suggesting that defraud, etc., has been committed, may refer the matter to central government for investigation by an inspector or inspectors as may be appointed by the central government. On such investigation, if the investigating authority reports that a person has committed any offense punishable under Section 213, read with 447 of the Companies Act or with so and so sections of INB Code, in such case, the central government is competent to refer the matter to special court itself or may ask the IBBI or may authorize any person in terms of 236 subclause 2 of INB Code to file the complaint. So what we've read till now has been upheld by the NCLAT and have been followed by various adjudicating authorities or NCLTs. Now, this is also an interesting case of Honorable NCLAT, Almas Global Opportunity Fund matter. And in this, there are three paragraphs which I would want to highlight here. Honorable NCLAT held that it is necessary to clarify that any observations made by the adjudicating authority in the impugn order regarding the ingredients of the offense under Section 74, subsection 3 are neither binding nor determinative of any issue when special court where a complaint is filed proceed with the trial of offense. So whatever has been adjudicated by NCLT, it's not a piece of evidence that you will be able to place it before the special court for the purposes of trial. It's a piece of evidence for taking a prima facie opinion or cognizance of the matter only. Thereafter, the judgment reads that the observations made by the adjudicating authority has to be read only for the purposes of sending the copy of the audit to the board for consideration of filing a complaint. And order of the AA cannot be treated to a direction to initiate action under 74 subclause 3, which is in the domain of board and central government as per the statutory scheme of the code. This judgment continues to the next slide. A copy of the order passed by AA shall be sent to IBBI and Secretary Ministry of Corporate Affairs to consider in terms of 236 subclause 2 to initiate appropriate complaint before the special court as envisaged under section 236(1). The direction cannot be read to be a direction to initiate complaint. Rather, it has to be treated to be a direction to consider for filing a complaint, in which I just stated a while ago, that is only for the prima facie cognizance purpose, not for determinative purposes. So summing up here, how does it flow? We have seen what the court has held. And this is what court has held. I'm just correlating with the sections and the judgments, and then we can open the floor for Q&A. The special courts have sole jurisdiction to take cognizance and prosecute for offenses under the code. So it is only the special courts who can do it. And we now know its session code as per 236(3). Neither the NCLT nor an IP can initiate prosecution. That was held by NCLAT in Mr. Sapan Mohan Garg's matter. Cognizance of an offense can only be taken upon a complaint by IBBI or the central government. 236(2) is very clear on this. NCLT, however, can grant liberty to an insolvency professional to make appropriate representations before IBBI to initiate prosecution. We have seen one judgment of Ashish Arjun Kumar Rathi. That said, NCLT's liberty cannot be taken as a direction to initiate prosecution, the judgment which we have just seen. Rather, NCLT's role is to identify, felicitate, and direct IBBI to consider filing a complaint to special courts and initiate prosecution, which we have also seen in the same case. I'm done with the PowerPoint presentation. We can all deliberate, contemplate, and I hope I'll be able to answer a few of the queries as well. I'll be yeah, it should be done.
So what happens is that an application is filed for preferential, undervalued, and fraudulent transaction.
PUFE, yes.
Yes, PFE. And court makes a determination. NCLT makes a determination for preferential transaction.
Yes.
And for undervalued and fraudulent, no determination is made by NCLT.
Okay.
Can it say that there is a recourse available to insolvency professional to file an application to IBBI to consider the same, to file an application before a special court?
Yes, 100%. So basically, there is no bar here that you cannot file a complaint suo moto. There is no bar stating that only when NCLT gives you a go ahead, you can file. You can very well file a complaint with IBBI if you have documentary evidence, the horse of NCLT adjudicating in favor or against the POF application. So let's say even if a POF application is not filed, can you directly go to IBBI? Answer is yes. So if in a PUFE, 100% you can, because now you have some kind of a substantial evidence, be it in a form of a counter or the order of NCLT, which also touches upon the other aspects apart from the PUFE. So yes, you can.
Mr. Amir, you earlier referred a case with the Regional Provident Fund Commissioner violating the moratorium, right?
Yes, sir.
Yeah, in that it was held by the NCLAT that the Provident Fund Commissioner is at fault. Is that right?
Yes, so they were the applicants and they were found to be faulty by the NCLT. You're right, sir.
Yeah, because you would say that IT people, regional provident commissioners, they normally do this actually. Even when there is
So
a
in this
moratorium,
case,
they don't
you are
mind.
very right, sir. You're very right. In this case, what happened? They filed a application. They were the applicant and they were held liable.
Yeah, exactly. That's precisely I wanted to know, in fact.
Yes, sir. It's true, sir. That's how it happened in that case, sir. You're
Okay.
very right.
Yeah,
So
in
as
one
per
of
the
my
judgment,
case,
1 minute. As per
Yes,
the
sir.
judgment, the Provident Commissioner has to go to the IBBI and ask for it. Is that right?
I'll just read out that part, sir. Second respondent, who was the liquidator in this case, was given the liberty to approach IBBI to proceed against the EFPO commissioner who have erred in their official capacity.
Okay. Okay. Right. Right.
There was a 60 subclause 5 application for some other purposes
Hmm.
where the respondent number 2 was made the liquidator. I presume that R1 would have been the company represented by the liquidator. So happened in the pleadings of the matter and in terms of arguments that the court NCLT has ordered the liquidator to go against the EFPO for the violations and for the penal provisions.
But that normally we should not, we don't venture, right?
Yeah, but I mean,
Okay.
my highlight was only for the purposes of who and where this penal provisions have been invoked, sir, not to say who's right and who is wrong.
Okay, fine. Right. Fair enough.
Only for that purpose.
Cases. Yeah, hi Anuji.
Thank you.
I
Shankar.
see.
Manoj, I'll take
yeah,
1 minute for Manoj, I'll take 1 minute for you just started. See, that particular case was before evolution of this PF actions, claims, and the PF they consider PF department are above God. They will come all in the last moment. No law is above them. They will not give claim, and end of the day, they will watch proceedings and jump, pounce at the liquidator or the RP in the last moment. This particular case has exactly, they did some ask for certain documents in the last moment, and liquidator was like, stumped. And liquidator was none other than learned technical member of Delhi bench, Mr. Ravindra Chaturvedi. So this case has a history.
In his earlier avatar.
He was the liquidator those days. Manoj,
actually,
yeah.
yeah, Amarji, I'm continuing this PF provisions there. As a IP, my colleague IPs will also fortify my this particular stand. What is happening is that because of their special status under section 36, subsection 4, subsection 3, subsection A, they come out whenever there is any we issue the notice form A, they come out with things that these are the dues applicable to us. And secondly, when they go for the assessment under section 7Q and 14A, they calculate interest since the beginning and all this in there. Maybe it is a 7-year-old or 8 years old, something like that. And in definitely, and the other thing is that they always ask for the inspection of our documents. They have a right under PF to go for the inspection. Whenever they ask for the inspection, I always say to them that because now recently 2 months ago one NCLT judgment have come out to be there, whereby they have very clearly stated that in case of PF dues, they can't do any assessment after start of the CIRP. I referred that case to them. And I referred the relevant section which you have just stated there, that filing of since this judgment clearly states that no, you can't raise any demand against me by having that particular assessment. And despite that, if you raise your demand, you will be prosecuted under so and so section. This process just started. We also learned with the passage of time with the experience. This I am writing to them. Despite all this thing, they are going for assessment and raising a demand against my SSC. What pain I have is that they're unnecessarily demanding a lot of interest, a lot of penalties from us under 14Q, 7A, 7Q, their relevant sections. At the same time, our creditors are sacrificing a lot because of huge haircut and something like that there. If now my question to you is that despite during substance proceedings or I convey to them that these particular judgments said you don't have any right for the assessment. Number one. Number two, despite that, if you file a claim against me, then you are liable for the penal prisons. can I, if despite that they go for the assessment and just raise a demand against me by filing Form B or something like that, I refer their matter, they try to see my limitation. They are the government authorities. PF Commission is a government authority. Can I refer the matter to the IBB and create history that, in one of my case, I've gone against PF Commissioner for prosecution? Please guide for that.
100%, sir. I do not see any. See, sir, making a complaint, first of all, you will also agree that it's our right. There is no way that we can't make a complaint. The IBBI and the central government are vested with the discretion whether whatever documents we have given to them, based on that, are they of an opinion, then the word uses opinion, that they want to go ahead and file a case in the special court. So answer, very simple answer, if I may say, yes, we can. Another way is, sir, there can always be an application to NCLT taking a rider of this judgment, stating that what they are now doing is not as per the provisions of the code, and which is now hampering the whole process. And then the points which you mentioned about the creditors and then the harassment and everything. Based on that, if you get an order, I think that could also be utilized for either going to the IBBI as well as to the NCLAT. But there is no bar that I mean, see, sir, we have seen in last 8 years or so that insolvency and bankruptcy code has only matured through the judgments. Most of the amendments are because of the judgments which have been passed by the tribunals or the NCLATs or the Supreme Court. So I would always strongly suggest that, sir, there is no harm in making a complaint to IBBI. And if at all we want to, let's say, sound a little diplomatic, we can always ask for guidance or directions from IBBI rather than a complaint. And also, when a file 60 subclause 5 read with Rule 11 NCLT application, it can be more of a nature in terms of clarification rather than, so to say, cribbing from our side, just to get a clarification, sir. That could be my softer suggestion, sir.
No, since you've been deliberating on prosecution specifically, that is why I asked this thing there. IBBI has been highly cooperative to us. There's a very big misconception among the IPs that IBBI is always with,
No, sir,
better
we have
with
seen the orders.
against
You're
us.
very right, sir. We have
Not
seen
at
just now,
all.
we have seen the
They
orders.
are very cooperative.
Very
Even if
cooperative.
we ask for some clarification, they do give very quickly and guide us also many times. In any case, as far as the first party which you just told me, in that case, liability definitely get extinguished and their claims are nullified. But I'm the president of my association. I'm receiving a lot of the questions from my fellow brothers, and including my IP professional sitting here, is that PF people are really creating a havoc for we people. They are on the verge of really, in any process, you go for any process, and what they do practically, they will look your GST returns, they will look into some of your IT returns, and from there they will pick up some data, and based on that they will impose interest penalties on you, which is most of the time hypothetical. I request my other professional colleagues to do also share their experience in insolvency process cases. But what I have seen it there, and I'm really thankful that you're allowing me that we can try for that also, because once we go for that particular situation, in that case, the panic which these PF authorities are creating against us, that will definitely going to
We just need
die.
one NCLAT or one Supreme Court judgment to set everything right, sir. And
Yes.
one insolvency professional like you who go through the whole food chain, go to the
Yeah.
top, and then set a precedent for all of us. Because that is how the
Yes.
code has shaped, sir. To be very honest, that's how the journey of IBC has been. Because rather than just adopting it from there or just going by the guidelines, rules, and regulations, I believe we have got a benefit in under IBC, though we always keep on saying that we have teething problems. I take a flip side of it. I see that it has always been a learning process for all of
Learning.
us.
Yes.
Because then we are eradicating all the loopholes and then trying to move forward in a manner where it is slowly becoming a very robust mechanism. And as you rightly stated, sir, IBBI has come up with so much of orders, so many regulations, so many guidelines. They have actually been a very nice and a strong pillar of the whole ecosystem of IBC.
Exactly. Yeah. Okay, my second question is that has special court ever prosecuted anybody based on the complaint filed by the IBBI? You have stated 7, 8 cases for our
Yes.
guidance.
So
Have they
sir,
prosecuted anyone?
yes. So basically, there has not been any reportable judgment, but I have gone through three orders. In one of the orders, the passport was impounded of one of the accused.
In case of
So
PG,
yeah, no, I don't know whether that was a SRA or whether that
in
was
case
a
of
PMP.
PG, there is a inherent reason for impounding of the passport. In that case, even NCLT do.
No. I'm saying about this. So basically, IBBI has made a complaint. Based on IBBI's complaint, special court has taken cognizance. While granting the imprisonment, the passport was also impounded of one of the persons. Now, I don't know whether that person was an SRA personnel or the ex-management personnel. And I've gone through two more judgments in which the ex-management has been granted bail. So that goes on to say that they were imprisoned. So at least three matters I know of where these kind of prosecutions have ended up in an imprisonment or with fine or with both, which I've just stated so many times again and again, has been taken a good shape into, sir. So there have been three matters as I know, because special courts matters are not very much available on the websites or live law or bar Indian
Yeah.
not reported. But in my independent research, I was able to get three of them at least, sir.
Please share these three matters. That will really help our IP community in
I
understanding.
will definitely, I will, sir. I'll share
Thanks a
the
lot.
three
Thank you.
judgments.
Thank you. Thank you.
Okay, a question in the chat. Before that, one question, sir, I would like to ask. If special court orders for fine, whether who will get this fine? Whether it goes to the Consolidated Fund of India or the CED is eligible to get this fine amount. How
No,
it
sir.
happens?
This goes to the Consolidated Fund of India only, sir. The reason being, if it is in a form of a penalty by the NCLT, there also they have a discretion where it should go. For, let's say, for PUFE or for contravention of moratorium or resolution plan and all those amounts, or the invocation of bank guarantee, that amount fallbacks to the corporate debtor entity's bank account, be it a CRB bank account or a liquidator's bank account. But when we talk about the penal, it goes to the Fund of India, sir. Because
So we have,
and I'll give you a correlation to that, because every person who trials these matters as per 236 is a public prosecutor. And once you see the framework, public prosecutor, special court, central government, it goes to the Consolidated Fund of India, not for the beneficiaries. For beneficiaries is always NCLT, sir. It is only for the penal provision, and penal always goes to the Consolidated Fund of India.
so we have a question in the chat. That's by KK Sharma. The company is undergoing CARP and resolution plan submitted by B company has also been approved by COC with 98.14% voting in their favor. Now, the suspended promoters are PMLA, maybe arrested or fall under the PMLA. ED has Enforcement Directorate has issued notice to SRA. What are the remedy available with SRA subsequent resolution applicant under section 14 of IBC?
No, so basically, sir, when this is a clean slate theory, sir, SR judgment, very clear cut judgment of SR Steel by Justice Rohinton Nariman, that when the company SRA buys the company, he gets it with a clean slate. So all the prosecutions qua the company, SRA does not adopt, SRA does not take it into his head. The prosecution which are ongoing qua the ex-management of the erstwhile board still continues, and they are supposed to face the penal consequences. So for as far as SRA is concerned, it's a very simpliciter application before the NCLT, and ED can be made a party, and it's a very easy case to do it, sir.
Yeah. Sir, let me also speak out because I am the KK Sharma.
Please, sir. So you should be able to throw some more light. I'm sure what I just suggested you must have already done, and there's further facts to that. So please bring it, sir.
Just I have put this question because
Sir.
SRA is being grilled by the ED. The questions, what is that the SRA has put that there were two FIRs under EOW.
Prior to SRA getting the company,
Correct.
they're not liable, sir.
Before that, now ED says that SRA has put into the resolution plan that these FIRs should be quashed
Qua the
as far
company.
as the project is concerned. As far as the project is concerned,
Sure.
not with the third party or any promoter or any other things
sir.
that you can grill it.
Yes, sir.
Now what they are saying that you are getting the company at a clear slate under section 32. What is the necessity to write those FIR into the resolution
Sir,
law?
have you tried filing an IA before NCLT bringing
No,
the
no, not
DPS?
yet, not yet, because it
Do it,
has
sir.
just
Do it, sir.
started.
It should be a very. I mean, obviously, I'm not do it. We have not gone into so much of facts, but it should be a winnable case, sir. If you go before NCLT, sir.
Any judgment or anything is there related to such type of issues?
Not on the aspect of ED, but on the aspect of clean slate theory, and that the liabilities
Like,
and the criminal prosecution qua the company is not taken forward by the SRA. There are many judgments. Not
well,
only the ED, but criminal prosecution, yes.
because SRA is such a nice company, they have got some principle into it. Even then, they are thinking now to
No,
back out from the
that's right.
because
Me,
they're
me and sir just discussed about setting precedents. You're getting an opportunity. Please set a precedent, sir.
You
so
have a very good case to save your SRA, because getting an SRA is not easy nowadays.
It has become very difficult. You're very right, sir.
so nice of you. If anyone has got such type of case and any judgment in relation to such type of, which is not exactly 100% matching to such type of case, anything like 20%, 25%, 40, 60, 70% matching with such type of issues, if somebody can refer it, it will be better for me.
I'll
Thank you,
ask
sir.
the team to do it, sir. I'll ask the team to do it, sir.
Thank you. Let me welcome the Vibrant Secretary of Kerala Insolvency Professional Forum, CS Ramachandran, for vote of thanks.
Good evening, all.
Are there other questions remaining? Are there other questions remaining to be answered?
Nothing more in chatbot actually.
There are no questions remaining in
No
the.
more questions in chat.
I think that chat questions are done. If any of the participant has, I'm ready to answer.
सर ये शेयर कर देना पीपीटी भी और मी इन नॉर्थ इंडिया ऑलवेज स्पीक्स इन हिंदी आई डोंट नो शेयर द पीपीटी आल्सो
मैं समझता हूं सर मैं समझता हूं
you know in my deliberations I always mix up Hindi and English, but whenever Kerala side is there I confine myself to the English only. Sir, please share this PPT also and share the recording also.
Yes, surely, sir. Sir, Amir Bhavani sir is pan-Indian.
What you said? I couldn't understand.
He is a pan-Indian.
Pan-Indian. Yes. Yes.
Joy sir, can I invite Ramachandran for vote of thanks?
He has got a pan and he is Indian also.
Yeah, good evening all. This is Tim Ramachandran, Secretary of the KIPF. Who can initiate penal action is the $1 million question actually. It's simply answered and a very nice presentation by Advocate Amir Bhavani. Thank you all for your wonderful presentation. And Manoj Kumar Anand, representing AIPA, Prem Kumar Chain, GIPA, PT Joy sir, KIPF, Sean, KIPF. Thank you all for all the decent presentation, nice interaction. Thank you all the participants for the presence.
Sir, one last thing I have to say, we have a resolve in Mumbai on Monday and Tuesday. If any of the participants or any of your members is joining, I be also there as a host there. So please be in touch with me there. We can it will be love to see whosoever be there from there. It's in the Mumbai on Sunday and Monday for 2 days, organized by our Institute of Chartered Accountant of India. It's an international event on IBC.
Thank you, Manoj sir. Let me invite our chairman, PT Joy sir, for the concluding remarks.
Now the concluding remarks, let me limit to saying that, excellent fees extended by Amir Bhavani as usual. Now, in fact, one question that remains, it is, when we are inviting him for a physical meeting, that we are looking forward, and let us make it happen. So maybe in the days to come, months to come, or years to come, let it happen. So my sincere gratitude and thanks to each one of you without exception for coming and attending. Thank you, Manojji and Paravinji, for being with us, taking things forward. Together, we will work out more programs in future. Thank you and wish you a good time. Bye.
Thank you, everyone. Thank you once again for calling me. And yes, sir, I look forward to the physical interaction.
Thank you, Amul sir. Thank you. Yes.
Any queries, please do let me know. Thank you so much for inviting.
Definitely. Thank you. Thank you once again.
John, you are right that the guest does not look like advocate, but looks like a film star.
Right. I have seen him personally. Very tall, handsome person.
I'm now embarrassed. I'm out of words. I can only say thank you.
Later, it can be a lawyer turned actor. No, it can be later.
Yeah, very much, very much.
Let Jolly LLB 5 be made by him. He be acted in the Jolly LLB 5. Okay, bye.
Thank you. Thank you so much, sir. Thank you.
Thank you, sir.
Thank you very much.
Thank you all. Thank you.